Emily, things are going very crazy in the Washington, D.C. Now it's either now or never for the Indian nationals who've been waiting for the green card. What's going on in Washington, D.C.?
Yeah, we had the Eagle Act, HR 3648, was actually scheduled for a vote today, which was surprising. It seems to be scheduled and then it gets off the schedule and scheduled again and then off the schedule. So we'll talk about what happened with that, as well as a situation that's coming up more and more commonly right now for people who have their I-485 adjustment of status application pending and suffer a job loss. What are the options in that situation? What are the things to be worried about there? And of course, with these visa bulletin dates going back and forth, we've got people who downgraded to EB3 and then upgraded back to EB2, and now EB3 advances again. What should you do in that situation? What are your options there?
First, let's discuss about what's going on in Washington, D.C. For those people, I just want to educate about the immigration history, especially for the Indian nationals. I just, so that you be aware of what's there in for us and how we've been treated before, how we are treated right now. Until 1952, Indians were not allowed to become citizens at all. Even if they have a green card, even if they serve in the military, they were not allowed to become the U.S. citizens. There was a law that prohibited them to become citizens. However, there was some exceptions given for the people who owned some land in California. Before 1923, they were some citizens, but because of the Supreme Court decision in 1923, all the people who already have been given citizenship are also lost. So practically, only white, free Americans were allowed to become citizens. Since they said that Indians are not considered to be whites, so their citizenship will be ripped off. So whoever who wants to apply for citizenship cannot be allowed. Whoever were been given citizenship were being taken off. Due to that Supreme Court decision in 1923, 50% of the Indian population just left the United States. We don't know where they went. It's a very long history. So until 1956, no Indian was allowed to become a US citizen after the Supreme Court decision of 1923. Even those people who have been given citizenship and been taken off, starting from 1956, Indians were being allowed to become US citizens. Then what happened? In 1964, a lot of this legislation came in about the employment, in general immigration, and the lottery system and all those things. They have given preference to indirectly to the Western European countries. So if you look into the employment-based application, they said 7% limit. Why should they keep 7% limit? They shouldn't have kept 7% limit there. And if you look into the visa lottery system, Indians are not allowed to participate in the visa lottery system. No, they're not allowed to participate in it. They made the laws in that way. Now we had this Eagle Act that came into picture today for debate, and we're going to discuss about who debated what and what is the course of action that you need to take. Emily, anything, what do you say about Joe Lofgren, our dear congresswoman from California?
Yeah, she did a great job in the debate today. Obviously, they were limited in the amount of time everybody could speak, but she gave very succinct explanation as to why this bill is needed, who it helps, who it doesn't hurt, and was able to kind of give counterpoints for everything that everyone else was saying about this bill. She made it very clear that it doesn't negatively impact anyone. We have this 9-year transition period. It doesn't impact nurses and physical therapists. They have a special carve out. It helps the documented dreamers. It doesn't negatively impact religious workers and people from the Caribbean and Black migrants and all those things. She had a counterpoint to pretty much every argument people were trying to bring against it, which was really great to see. Then we had just some other people. Pramila Jayapal, she had a good explanation. She went through this personally. She was on H-1B.
It took 16 years for her to get the green card when priority dates used to be current for her.
Yeah.
She probably didn't have a good immigration lawyer.
So she understands that people are basically in a situation where they might die waiting for a green card. It can take decades, 100 years, century to receive a green card. She also pointed out that this actually helps Mexicans and Filipinos because On the family-based side, it increases the cap to
Increases the cap from
15%.
7% to 15% for the Mexicans and the Filipinos.
And she also pointed out that this, basically the same bill, had 365 supporters previously.
And it was also passed in the Senate too. Now, one thing surprising, Emily, is that not a single Republican congressman came to the floor and supported. We have seen Republicans, Congressman Tom McClurtuck from California. He opposed the bill. We had Representative Chip Roy from opposed the bill, especially from Texas, residing in San Antonio area. He's definitely opposing the bill, and I'm a bit worried about the kind of speaking they did, though, because Tom McClintock from California says that this bill actually, he says that all Americans are one race, and why does he then brings Indians and Chinese as a separate race? The debates that we're discussing about is that these people who are on non-immigrant visa are able to, especially Chinese people, they are spying. And if they are spying, we should go after those people and oppose. If they are on H-1B or if they are green card, how does it make a difference for you? If they are spying, they are spying. We should go against those spying agencies and
there's already law for doing that.
Yeah,
Why do we need to
FBI,
add additional law?
Yeah. So that's one thing. And then we have some people discussing, especially Representative Andy Biggs from Arizona. He's discussing about border control. What does border control has to do with this bill? And Congresswoman Joe Lufkin clearly explained to them, look, we are not increasing the number of green cards. There's not a single increase in the number of green cards. It's only taking the discrimination off. What was been discriminated from 1964 to right now has been taken. This covers to an extent, not fully, but it's taking the discrimination off and treating everybody equally, which should be treated like that. Those were the arguments made. So we may expect to get out this week or probably next week. We expect all the people to contact the congressman. We have given a draft of the letter for you to contact. And please write your letters to the congressman to contact the congressman. Emily, anything more on this one?
Yeah, and of course, remember that even if we make it past the House, we still have to make it in the Senate as well. There is a Senate version of this bill that was introduced back in July, if I'm not mistaken. It now has 3 co-sponsors that added on in September. Has not really gone anywhere. Of course, if we see this pass the House, hopefully that will trigger someone to bring it for a vote in the Senate. But we're limited on time. I believe the Senate's legislative calendar, they're done December 21st, and the House is done the 15th. So we really have to get this out of the House this week and then to the Senate next week. And then hopefully they pass the same version, which is where we failed last time. They passed 2 different versions and then there wasn't enough time.
So a lot of people ask this question to me, Emily, that if my representative who is Republican is not going to be in favor of immigration, should I contact him? Why should I contact him?
Yeah, I think you should still contact them and explain all of these talking points of how it impacts you, make your voice heard, so that they have to stand for that if they later decide to vote against it.
I definitely want all the people to contact the Indian organizations. Immediately, you should contact these people who are supporting the Republican Party, especially those people who are funding it, both parties. Why not? All the people who are involved in it, the Telugu associations, the Hindi Association, Maheshwaris Association, Agarwal Association, all these associations, you should contact them to contact the congressman to make sure that this bill is being passed. It may be in the short run, we want a lot of push right now. We may also need a lot of push afterwards too. But these 2 weeks are the most crucial thing, even though they're saying that the House will end in 15 and the Senate will end in 21st. We always see that they always come back after Christmas sometimes to pass any of the bills. So if we can sneak this in, this is not that important for them, but there are other bills that are important for them. So they may be able to pass this in by January 3rd. Why this bill cannot be passed after January 3rd is the new Congress comes into picture. Congresswoman Joe Lofgren is not going to be the Judiciary Committee chairman, and it's going to be Republican Party. We don't know what their stance are, and and typically these kind of semi-controversial bills will be voted in this session. We call it as lame duck session. So if we lose that, that's it. Then we have to wait for the next lame duck session. If you recall, 2 years ago, it was in the lame duck session that it got passed in the House, it got passed in the Senate. It just did not have time enough to reconcile the bill and get it over because the versions of the bill were a little bit different. So hopefully so that will be cleared right now. If not, then we may have to wait for 2 years, as Congresswoman Pramila has said that it will take 200 years for you guys to get the green card if this bill doesn't pass through. And most of you guys will die waiting for the bill, according to her and according to us too. So this is not good for United States. This is not good for you guys. Please have everybody write letters. You got something?
All right, so we wanted to talk about the situation where you have your adjustment of status I-485 pending in the employment-based category. What happens if you lose your job? We're hearing lots of talks about layoffs happening right now. What are your options in that situation? So remember, number one is when you have a 485 pending, it's been pending for at least 180 days, you are eligible to take that green card process with you to a new employer under what we call AC-21. The new job offer has to be similar to the job that you were originally sponsored for. It doesn't have to be exactly the same. It can be different title, it can be different job duties, different SOC code, as long as it's not too different. It can be different geographical location, different salary, as long as it is similar to the job, not even the same industry, but similar type of job. You can use AC-21 to move that green card process, keep it going with the new employer.
So Emily, what if I don't find any job? What do you recommend? Can I be self-employed? Why my wife employ me?
Yeah, that is an option. AC-21 does allow self-employment, even though normally in immigration, self-employment is not allowed for an H-1B or something like that. Once you have your 485 pending, you can port the 485 from your existing employer to self-employment. We've done that a number of times, had the person who, the applicant, they started a company, we provided all the documentation showing that the company was up and running, and they filled out the Supplement J form themselves and brought it with them to an interview so that they could show that they had ported to self-employment. So that would be another kind of backup option if you want to start a business and use that.
Emily, I'm working for Facebook, which is one of the top companies called Meta right now. And now I got laid off. Can I work with a hospital and IT job? Is that going to be a problem?
Yeah, no problem at all.
What if a consulting company, just working for a consulting company?
No problem.
What if I was getting $250,000? Now I only get $150,000. Is it okay?
No problem at all.
Okay. And what if I was working in Seattle and now I get a job in Florida? Will that be a problem for the moving from there to here?
No problem at all.
With regards to the self-employment and wife employing you or spouse employing you, it's perfectly legal. In fact, in their memo, they have clearly mentioned it though. But I will take it with a pinch of salt because, yes, you can employ us. We will defend you and we have been successful in that. But if you can avoid us, that's always good for you guys. I mean, if you can find some other company that you have a job with where you can get a job and be employed instead of your own self-employment, or your wife, spouse employing you, I would recommend that. Because when we go to the interview, when we have to explain to them that the self-employment and all these things, they don't understand it. It will take a lot of time for us to convince them. They'll have to go to the supervisor. We have to write a memo to them, and which we have done it. We have been successful in it. But you would like to avoid us making a lot of arguments for you.
All right, so we've been talking a lot about these downgrades ever since October 2020, going on over 2 years now, and then everybody was able to upgrade, filing that transfer of underlying basis with the Supplement J when EB2 became current. Now we're back to retrogression and EB3 is moving forward. You probably get this question a lot on your daily conference
Yes.
call. People wondering, should I switch back to EB3? Do I file another 485? What should they do?
Yeah, if your priority date is becoming current, or you know for sure it's going to become current in EB3, I would refile the 485J supplement, saying that now I want to consider myself to be considered an EB3. And people ask me the question, oh, I'm not working for the same company that filed an I-140. Well, that's fine, because neither is EB2 filed by the same company, neither is EB3 filed by the company that you're working. You can still port to EB3 by filing a 485J. Instead of keeping the EB2 I-140 approval in the 485J page number 1, you just keep the EB3. You can still port the things to EB3 to adjudicate. And what I would normally do is, if once I file the 485J supplement under EB3, I will definitely consider writ of mandamus, where you can sue the USCIS. Why are they taking such a long period of time if the 485 is pending more than 1 year? That is an option that's there right now, because who knows, these priority dates may move backward. So definitely you have moved from EB2 to EB3 in October of 2020, then probably in April to October, September or so, January or to September or so, January of 2021 to all the way to September of 2022, you may have moved back to EB2, and then now we are telling you to move to EB3. This is expected because a lot of people who are eligible for EB2 are also eligible for EB3, so they keep on switching on, going back and forth. And the USCIS and the State Department have no clue how the people behave. They have the numbers, how many I-140s are approved, but they didn't understood that we're going to keep moving from EB2 to EB3, EB3 to EB2, or probably they don't have a knowledge at the time, especially in September of 2020, they probably didn't have a knowledge that people can file the downgrade application and file a 485 application. They were completely blindfolded, and that's all I can assume at this point of time. But yes, you can, even though you are ported to EB2 to EB3 in October, and later on from EB3 to EB2, you can still port back to EB3 if you have an I-140 approval in EB3.
All right, we can get to some questions now. Kalyan says he has the H-1B approved back in September, but also had applied for an L2 extension before that. And thought it was going to be automatically canceled when the H-1B got approved, but the L2 extension has gotten approved as well, and wants to know how does he know which visa he's on, and can he withdraw or revoke that H-1B to continue with the L2. So only a company can withdraw or revoke an H-1B approval, and if they were to do that, it doesn't put you back in L2 status, it puts you out of status. But there is a solution, and that's called automatic visa revalidation. So whichever approval, whichever status you want to be in, you can, assuming both approvals have I-94s on them, travel to Canada or Mexico and return showing your visa stamp, which may be in a different category. It may even be expired, and show the approval notice for the status you want to be in, and you will get a new I-94 putting you back in that whatever status is that you want to be in. That makes it very clear which status you're in. You don't have to worry about having your H-1B withdrawn.
Amit is asking this question. If Eagle Act is passed, and let's say it's been introduced and passed in Senate and signed by the President, which he's expected to sign, what is the timeline for this? First thing is that the Eagle Act does not come into force until 2024 October. So that's when you will be able to file the adjustment of status. Not all the priority dates are going to be immediately moving, because it's going in phase wise though. So it's going to take a little bit time for the priority dates to move. But the good part about it is that if you have an I-140 approval that has been filed more than 2 years ago, that means, let's say for example, by October of 2024, that means that if I-140 has been filed on October 1st of 2022, which is about 2-3 months ago, that means that you can still file the 485 application in October of 2024. So the grant date, the date that you can file the adjustment of status, will be October of 2024. That's when you will be more free. And you know how once you file the adjustment of status, EAD is very easier to get it. You don't have to go to the end client letter, vendor letter, filing fees, or anything is required for the EAD. So that's October 2024 is the implementation date.
Sarath wants to know if we apply for the H1, H4, and H4 EAD extension and premium, and the H1 is approved but not the H4 and EAD. If I plan to travel to India and get both the H1 and H4 stamping, do we get the automatic H4 EAD extension? Yes, so assuming that you filed the EAD application before the current one expires, if you're able to return with a new H4 stamp and getting a new H4 I-94, from that point going forward, you do get the automatic EAD extension to allow you to get back to work.
A question with regards to are the Republicans playing the tactics, the delay tactics? Well, in the House, Sats B from is asking. In the House, though, it's controlled by the Democrats at this point of time. So unlike in the Senate, the House, the complete control is in the hands of the Democrats at this point of time. So it's definitely in the control of the Democrats. I haven't seen any Democrat, at least, they didn't vocally opposed in the bill at this point of time. There has been a black caucuses, people who belong to both parties, that definitely did not support this bill. In fact, they opposed this bill. So I don't know if Joe Lofgren is thinking that if it's going to be not passed in the House, why should I put it to the voting? So I don't know what her consideration was to have it delayed at this point of time. But we want you guys to increase the pressure on the Congress people to get this bill passed before January 3rd.
Vineet Kumar says, my spouse has a valid H4 until 2025 and also has an approved change of status to H1 that's valid till 2025 and wants to know if we travel to India, when she's coming back, can she use her H4 to enter the US? Yeah, so assuming that she has an H4 visa stamp that's already valid and not expiring until after she enters, she can use the H4 visa to come in and change back to H4 status. Of course, she would not be able to work once she does that unless she has an H4 EAD. But yes, just because she got an H1B doesn't mean she can no longer enter on H4 as long as she has the visa stamp and you're maintaining your H1B status.
Kunal Jain has this question. What's your opinion on EB1 retrogression? It's not my opinion. The USCIS has told us that it's going to be retrogressed for especially Indian nationals. It's going to be Indian nationals and probably Chinese nationals also. They said it's going to be retrogressed. So so for some of the EB1As, EB1Cs, EB1Bs, we normally tell the people to wait until I-140 gets approved. But at this point of time, if I'm filing an I-140, I'm going to file the 485 also. I will not wait for the I-140 to be approved because by the time the dates may move back.
Deepak has an H1B and his wife and children have H4s, and they also all have received their EADs from their pending green card process. And he wants to know for his daughter, should she use that EAD to work? Can she use it for a summer internship? What does that do to her green card process? What does that do to her status? So yes, she is authorized to work based on that green card EAD that she has. Once she starts working, she's no longer in H4 status. So you want to make sure that you are comfortable with her relying just on the adjustment of status and not having a non-immigrant status to fall back on, which can be fine. We've talked about that a number of times here of kind of the benefits of using the EAD and letting the H1B and H4 go. Obviously, you don't have to worry about those extensions all of the time. You don't have to worry about visa stamping and those sorts of things. So that can be doable. You want to make sure that your daughter's age is locked in under the Child Status Protection Act, or she's not at any risk of aging out, because you can still age out even if you file the 485 if in limited situations. You want to make sure that she's fine for that purpose. And note that if she travels, then after she's used this EAD, she would be coming back on the AP generally.
Question with regards to Sam has this question. Got the green card 6 months ago. Congrats. If I stop working or if I switch to a part-time, will it affect my citizenship application? If in 5 years I'm going to apply for citizenship? No, it does not. If you stop working, that's fine. If you switch to part-time, that's fine. A lot of people ask this question about this. Oh, they're going to ask the 5 years employment history. But they are asking 5 years employment history just to have a knowledge whether you're working for some bad, like let's say maybe if you're working for Al Qaeda, we don't want you to get the green card. Or let's say, for example, if you are selling drugs, I mean illegal drugs on the market, we don't want you to get the green card. So we don't want you to get the citizenship. That's the reason they're asking. If you're just sitting at home or switch to a part-time job, no, it's not a problem. It's fine. They just want the employment history to make sure that you are not doing wrong things. And they also are looking, let's say, for example, the terrorists or drug people, do you think so? They're going to say that I'm terrorist? They won't say. So what will happen is that the USCIS, if somebody is a terrorist, okay, and he's not going to say he's a terrorist, right? He's not working for a terrorist organization. So if he gets a citizenship, the USCIS can revoke the citizenship, saying that he lied in the citizenship application by not disclosing the terrorist organizations. So those are the reasons for which they're asking your employment history. In your case, Sam, if you just stop working, you say you're unemployed. If you're doing part-time, you say you're part-time working. Absolutely, it will not have any problem. None whatsoever at all in your getting the citizenship.
Retrospect asks, why is this country cap removal bill always introduced at the very last second? And then they say, we ran out of time, so we couldn't get it passed. Yeah, we've definitely seen this again and again and again. My answer to that is elections. You know, a lot of times with representatives and senators, they're always worried about, am I going to get reelected? And so many of them are not willing to stick their neck out and do anything that could jeopardize, in their mind, their chances of getting reelected. So of course, we just had an election this year in November. So now, because we had that election, we're in what's called the lame duck session. This is where a lot of bills can pass, because now we've got people who just got reelected, or we've got people who are leaving. They didn't get reelected, and so they're finishing out their term or they're retiring. So they may be a little more willing to say, you know what do I have to lose? I don't have to worry about being reelected anymore. They might vote for some things that they wouldn't have voted for before. So I think that's why we generally see these types of things happening in a lame duck session. They try to bring them, the bills were introduced much earlier in the year, but they don't actually get any action on them until after the election.
People are asking the questions that is it going to immediately get everybody to the equality where everybody gets an equal preference? Unfortunately, no. It's going to be a phased period. The first year it's going to be 30%. Then the next year it's going to add 25% extra, and so on and so forth. It goes on. So it's not going to be like immediately everybody will be treated equally, but it's a phased manner, in a phased manner of 9 years. But the good part is that you will be, even if the priority date is not current for you, if you have an I-140 that has been filed more than 2 years ago and it's already approved, you can file the 485 application. You practically will be an adjustment of status. So that's the great advantage of it, and especially children who are going to be aged out are also protected in this bill. So yes, it's not going to be immediately, it's going to be in a phased manner.
Money wanted to know about his wife had worked for 6 months for a company as a manager outside the U.S., but then came into the U.S. To work for that same company on H-1B, and wants to know, could she be eligible for EB-1C if she were to leave and work an additional 6 months outside the U.S.? Yeah, so the normal rule is that they look at 1 year within the previous 3 years. You have to have worked outside the U.S. for one total year within the 3 years. So if she has been in the U.S. for a shorter period of time, she could go back out, finish the remaining 1 year, and combine the 2 6 months together if they were within that 3 year period. They also have a special provision where they kind of readjust that 3-year window if someone came into the US for that same company on a different type of visa, like H-1B. So that may also help her in being able to establish the EB-1C criteria if she were to work for an additional 6 months.
Narendra has this question that in the adjustment of status, when you lose the job, what is the time period? Is there a deadline to get a new job? Narendra, the reason why you are going to get the green card actually is not the job, it's the job offer. Technically speaking about, let's say for example, you're working with Meta. So that means that you have a job offer with Meta. Now, when Meta terminates you, if you don't have a job offer immediately from some company though, that may negatively affect your application at a later date. So it could be that you may have a job offer from some company, they may not onboard, or maybe you don't want to onboard immediately. Maybe you want to take a risk for 3 months or 4 months. That may be fine, okay? But the job offer is very important. However, Narendra, I would like to keep as minimum, if not no period at all, to be unemployed if possible though. Because if they see an unemployment period of time there, the USCIS, it rings the bell on their head. Oops, there is something wrong. Is there a genuine job offer pending or not? So I would like to avoid at the most maybe a week time. I would like to avoid, but if it is an extreme circumstances where you cannot avoid, then probably the job offer with unemployment may be okay, should be okay according to the law.
Shahul wants to know if the AOS gets denied, is the I-140 still valid and can I use it to extend my H-1B? Short answer, it depends on the circumstances of that 485 denial. Let's say it was denied because there was a problem with the medical exam. Well, that has nothing to do with the validity of the job offer. The I-140 remains intact, so it is still valid. However, can you use it to further extend your H-1? Depends on whether that final action date is still current. If that final action date is still current, generally you're not allowed to keep getting H-1 extensions beyond the 6-year limit unless you have a pending 485. So in that situation, you may want to consider refiling the 485 in order to be able to continue to extend the H-1. Now, if the AOS was denied because the I-140 was revoked, because the job offer isn't valid or the labor certification was invalidated or the company withdrew the I-140 or something like that, then the I-140 is no longer valid and then you would not be able to use that for continued H-1 extensions. Basically, the ability to keep extending the H-1 based on an approved I-140 ends when the final action date becomes current or that I-140 is invalidated.
Money has this question. His wife has worked as a manager outside the country.
Oh, I just did that one.
Oh, you just saw it. Sorry.
Sachin has a good question. Isn't there something that the executive branch can do to help the backlogged community? Is this solution only legislative in nature? There are some things, and we've talked about this before, and we have some sample letters. We've tried some advocacy efforts there. The biggest, in my mind, is stop counting the dependents toward the employment-based green card numbers. That's how the statute was written, but the way they've been interpreting it all along, they count the dependents towards that 140,000. So really, we're only getting 40,000 people that are actually the workers, and the rest of the green cards are going to family members using those slots up. That is something that we feel the executive branch could change without needing to go through legislation. So if this EAGLE Act ends up not going through, that's probably something starting in January that you may want to look at advocating for.
Emily, can we not sue since the statute is neutral? Can we not sue the USCIS because?
I believe that there have been some cases before, particularly from some EB-5 applicants who argued that the dependents should not be counted, and the court either disagreed or dismissed for lack of jurisdiction. I don't remember the outcomes of those, but it was not successful.
Especially when the law is not clear, then it's up to the administration to interpret it. So we cannot go and force them to implement it in our way, though. However, the administration can interpret, because it's, you know, they can interpret the way that they don't have to count the family members. We do put a draft of that one too, but at this point of time, I want you to emphasize more on the EGAL Act. And if we see that by by January 3rd, if that doesn't pass, then we have to go only with not counting family members. Because now the EGAL Act, if it doesn't pass, then we have to wait for the next 2 years to get it passed.
Sandy wants to know, for H-1B visa stamping, can we update the DS-160 after we've made the appointment, because the H-1B approval number is different? Yes, you can modify the DS-160 after you've submitted it before you actually attend the appointment. We do actually have an article on our website. If you go to rnlawgroup.com and look for DS-160, that should pop up. It kind of walks you through how exactly to get that accomplished.
How many months will the EB-1A will be retrogressed, when it's going to be retrogressed? It may retrogress up to 2 years, that's my estimate, but we never know. Sometimes it may retrogress even longer period or short period, but 2 years is what my natural guess will be.
Moni wants to know your H-1B extension without the I-140 when the perm is still pending and has not been pending for over 365 days. My employer says there's a litigation and we can file based on that. Is it really possible? I'm not aware of any litigation on that issue. If the perm has not been pending for 365 days by the time of the start date you're requesting, then you cannot get that extension. So it all depends on what start date you're requesting. When are you actually hitting your 6-year limit? So basically what I'm saying is you can actually file the extension in advance before you've hit 365 days, as long as the start date you're requesting, by that point, the perm would have been pending for 365 days. So that's something to consider.
ARCO, I got my green card under EB-1. Do I still need to go for stamping for L1A visa in India? No, you don't need to. You're good. Just use the green card to keep traveling. Vexwell has this question. PhD with 2 publications. One publication is 82 citations. That's good. Peer-reviewed 2 publications as of now. What are my chances of EB-1A or EB-1B? Very good chances. Nowadays, the administration is a little bit more liberal as compared to previously. I want you to watch the video that says EB-1A, Reddy and Neumann. And I want you to try to, there are 10 points out of which you have to meet for 3. I want you to write down all the things where you think so, you may be suitable, and make an appointment with the lady. Her name is Vanita in our office. And please attach your resume when you make an appointment, so that when she discusses with you, then she knows what she has to speak with you. So that's a better way to evaluate, because EB-1A is definitely good. You should. You have a PhD, 2 publications, 82 citations, peer reviews done. You should take a shot at it. That's my opinion.
JJ wants to know, can I work remotely for a Canadian company and stay in the US on H-4 if I have no EAD? No, you cannot. If you're in the US and you're not a citizen or green card holder, you have to have work authorization to be physically in the US and work, even if the company is outside the US.
If the EGAL Act passes, does everybody get the green card? No, it's not going to be that quick, but at least most of the people, or if not very good number of people, would be able to file the 485 applications in October 1st of 2024.
Mangesh wants to know, if a person moves out of the US while the 485 is pending and the EAD and AP have been issued, what happens to the 485? Well, assuming that you don't come back and your AP has expired, eventually that 485 will be denied for abandonment. So if you plan on abandoning the 485, you may want to consider withdrawing it so that we don't waste government resources on an application that doesn't need to be processed. They can use those resources for other people that have pending applications.
Rami Chalugutla, he is intending to file the 485 application on a cross-chargeability. Well, Sorry, not Ramesh, sorry. This is Shahu Ahmed. He's intending to file the 485 under the cross-chargeability but doesn't have the birth certificate. Will it be any problem? Affidavits by the parents are enough. Sole affidavits from the parents, especially when it's a cross-chargeability, are not enough. You need to get a lot of other evidence suggesting why you don't have it. Most probably you're speaking about the birth is done in Saudi Arabia or somewhere in Middle Eastern countries. That's where you're speaking about. You need to get a lot of other evidences. Just the evidence that the Indian consulate has mentioned that the person was being born in the Middle East won't be enough. You need to get a lot of other secondary evidence from the place where that particular person has been born.
Rajiv wants to know, why can't they take the same version of the bill that was passed in the last lame duck session and use that this time around? That would be easier. I think there's a couple reasons. Number one, the representatives that passed the bill previously are not the same representatives who make up Congress today. We've had elections since then. Some people retired, some people didn't get reelected. We have new people coming in that have new ideas, may not be voting for that same bill, even though their predecessor may have. And also, remember that we had two different versions of the bill in the last lame duck session. The one that passed the House is different from the one in the Senate. So the new one is trying to take the issues that were raised during both processes to make the bill better, to improve the chances of it passing. If they just went back and did the same bill over again, the Senate's going to have the same problems with that bill that they did previously.
Thanks, Ramesh, for reminding about the voice. I did make some adjustment, hopefully so that will correct it. Abhijit has this very interesting question. Is it possible for transfer of underlying basis of EB 485 to family-based 485 for dependents of GC holders? We tried that a couple of times. It was a miserable failure. I would suggest, if they're eligible to file a 485 application, again, fresh. The second suggestion I would have is if they're not eligible for 485, because if they're not maintaining the non-immigrant status, though, the best suggestion would be to file the counsel processing. Now, while this application is pending, I mean, you should not touch this application, but do the counsel processing and get the counsel processing done. That means that they can avail the EAD, avail the advance parole, but they just have to travel to India to get the green card. And the whole process might take approximately around 2 to 2.5 years for you to get the green card.
Enkit says, my friend's relatives were not allowed to enter by CBP because they had left the U.S. without getting the biometrics done when they applied for a B2 extension previously, even though it was filed on time.
Yeah,
Can they go for a B2 visa interview? Yeah, so that is their only option. So basically what happens is if you file a B2 extension and you leave after your I-94 is expired, but before the approval, and the B2 does not ultimately get approved, which in this case it didn't because they didn't go for biometrics, which they couldn't because they weren't in the US at that point, it automatically cancels a valid visa stamp. And that's why CBP wouldn't allow entry. So they are going to have to go through the process again, fill out a new DS-160, go for a new visa interview, take the documentation showing that they did timely file the B2 extension, exactly what day they left, when was that biometric notice issued. And it's very unfair that that's how they were doing this. People didn't really have a choice in filing the B2 extension, especially if this was during COVID times. They couldn't leave, so they did the right thing, but now they're being punished for it because it didn't all work out in the end.
I want people very careful, though. People applying for the extension of B2, they are risking a lot, especially if you have heard this particular gentleman that they have been returned back. That means that they have been put in custody and sent back to their home country, which is not a good thing. So when you're applying for the extension, be very careful. These are the things that are negative consequences. I would strongly recommend to consult a lawyer before applying. I would just say that let them go within 6 months. Don't let them stay beyond 6 months. It's always risky. This question comes from Rajesh 2112. My parents came to USA, but there is the I-94 is not appearing. It's not updated online. It's been a month. What do I do? I would recommend it to make an appointment with the CBP office and go to their office and check it out, what's going on. There's a helpline where you can send an email to the CBP office to check if there is any discrepancy why it's not appearing, or make an appointment with the CBP office. Make sure when you go to the CBP office, take the passport and make sure that you take the flight ticket that your parents came in, because they want to look into what flight they came in, so to track those things. And always make an appointment at the place with the CBP office where the jurisdiction of the airport comes into. So let's say if it's Dallas, make an appointment with the CBP in Dallas. Don't make it in Houston, because they may not want to correct what happened in Dallas. So make sure that you make a proper appointment with them.
Kishore says, regarding the EAGLE Act, does the approved I-140 have to be from the current employer, or can it be a previous employer to qualify for that 2-year rule? So the rules do not change regarding the fact that you have to have an I-140 with the employer who's still sponsoring you in order to file the 485. The only thing that's changed is when you can file the 485. So it does need to be with your current employer, unless you are sponsored for future employment and that company is still planning to sponsor you and is supporting the 485 filing.
Can we travel multiple times on combo card within the same year? Absolutely. If the combo card has an advance parole and it's valid, yes, you can travel multiple times. Can you travel 10 times? Absolutely, you can. Can you travel 20 times? Absolutely, you can. There are some people in Windsor and Detroit, they travel a lot more times than what I just spoke with you.
Ashrita says her husband got his H-1B approval. Previously, he was on F1 and she came on F2, but her status is still F2. What's the right action that we need to take? Yeah, this is something that you need to look into very quickly. I do recommend that you consult with a qualified immigration attorney so they can look at the documents, look at the dates, the I-94s, and make sure the timing of everything, so that they can determine whether you could potentially file a change of status to H4 and stay in the U.S., or whether you should exit the U.S. and apply for a visa stamp. So there's a lot of information that is needed to guide properly on that, but definitely you need to take action as soon as possible by getting the right advice.
I got my perm approved, but when my school applied for my I-140, got an RFE asking why my salary is $1,000 more. How can I respond? Have it evaluated by a lawyer. That seems to be very odd that they're saying that it's $1,000 more. That should be easily approvable RFE if that's the only thing, but have it reviewed by a lawyer before you respond. Kunal has this question: if the EB1 gets retrogressed, so what will happen to the 485 application? It will be there, it will be pending. They will give an EAD, they will give an advance parole. They just cannot give you the green card, but they will give you an EAD, they will extend the EAD for you.
Remy has a perm that was recently approved and is getting ready to file the I-140. He's got a previous I-140 approval that gave him a priority date of January 2013 and wants to know, does it make sense to file both an EB2 and an EB3 I-140 now based on this labor certification, because you don't know which date is going to become current first? You definitely can do that, assuming that your labor certification was intended for an EB2 position. So most EB2 positions automatically can qualify for EB3, so that would allow you to file 2 I-140s using the same labor certification. You can file them both at the same time or file them consecutively, one after the other. Totally fine to do that.
Ajay Aloya has this question: can we travel to Mexico without having a visa stamping to come back into the United States? If you have a valid I-94, let's say for example you're an H-1B, and you have a valid I-94 or H-4, you have a valid I-94, absolutely, you don't need to have a visa stamping to come back into the United States. You can just go to Mexico and come back, then only if you're coming back within 30 days, only if you're not going for the visa stamping at all. If those circumstances are there, you are good. Okay.
The optimistic investor wants to know, on average, how long does it take to get the EAD AP card from the filing of the 485? I would say anywhere from 4 to 10 months, and I know that's a very wide range. And on top of that, you may not get the combo card. You may get the EAD in 3 months and the AP in 8 or 10 months. And there's no consistency to that. They started processing them separately because they claimed they could process the EADs faster that way, but then they don't care that the APs are taking forever. So it is quite a wide range, no rhyme or reason to the processing times.
How long, this question comes from Anil, how long can I stay outside United States on a combo card? More than, some people are saying that more than 3 months can cause an issue. I would recommend to keep under 3 months. If you are moving, if you're going out for more than 3 months, I definitely recommend that you contact a lawyer. Whenever I say contact a lawyer, man, it's better to avoid. It's not that you're going to get a good deal by paying money to a lawyer. If necessary, you should avoid. Especially for these kind of things, staying more than 3 months, it always risks your green card though. So try to stay less than 3 months, you're fine.
Soumya says, my mom stayed beyond 6 months on B1, B2 due to COVID and lack of flights. We applied for the extension, but she had to leave before the biometrics appointment came because those were delayed. Will she be allowed to enter? So this is a situation where she may be denied entry on the grounds that the valid B1, B2 visa stamp is no longer valid because of the overstay, even though she timely filed an extension. So you may want to consider having her apply for a new B1, B2 visa, especially right now while you can do it possibly with the Dropbox. Since they've expanded that, that may be a faster option.
A question that came in is that me and my wife are on H1B and H4. And if we travel outside, we have a combo card. If we travel outside, come back in, can my wife continue on the H4 status? Yes, she can. The USCIS is telling that they will extend the H1, they will extend the H4. You can transfer the H1. So I consider that you are on H1 because otherwise, why can they extend? And even if the I-94 says it's you're being paroled in, you're absolutely fine. You don't have any problem. You can still maintain the H1B, H4, and you can extend those things too.
Dheeraj worked for the Indian parent company for 4 years as a manager and then moved to the U.S. on F1. And now the U.S. subsidiary of that company wants to hire him in the U.S. and he wants to know, can I go for EB1C and change status? It sounds like you should be eligible because you would have worked for that company for 1 year within the 3 years prior to entering the U.S. So assuming the companies have the right qualifying relationship, which you mentioned parent subsidiary, so that should qualify. So you could then, assuming EB1 remains current, file the I-140 and 485 together to adjust your status from the temporary student visa to permanent residence. You would not be able to start working until you get the EAD. So you may want to consider first applying for a change of status to L1 to get the work authorization and then proceeding with the EB1 and adjustment of status.
Abdulaz's question, I got promoted after my prevailing wage determination has been filed. The job role is still the same, just more senior title. Does this impact my green card processing? It should not. If you were working for any of the FANG, that's Facebook, Apple, Google, and all these companies, it does not. If I'm your immigration lawyer, it does not, but it depends on some of the immigration lawyers. So. But most of the immigration lawyers agree with me that it's a natural promotion in the job, so you're fine. You don't need to file one more prevailing wage determination. Okay. Prashant has this question. My I-140 got approved in EB2. When can I apply for 85? It's been 4 months the I-140 has been approved. I don't know what your priority date is, Prashant, but you should know what a priority date is. If not, we have made some videos just what is a priority date. Once you watch the video, then you need to look into if your priority date is current. How do you know your priority date is current? Then you have to go to Visa Bulletin, and in there, you need to look into what category has been approved, but your lawyer will be able to guide what's your priority date and if it's current or not. So definitely, you seems to not have much knowledge about it, I need to know what's your priority date. If you don't have a priority date, we cannot tell whether we can file a 485. If your priority date is 2021, it may take, according to Pramila Jayapal, the congresswoman today, it may take almost 200 years for you to file a 485, according to her. And a lot of other organizations also are telling the same thing. So that depends on what your priority is.
Venkat wants to know, while the AP is in process and you need to travel on an emergency basis, what happens to the AP and what are the reentry options if the AP is not approved and you don't have the H-1B? So if you travel while the AP is pending, the AP will be denied. Even if it gets approved, you should not use it to return. That means your only option to return is to get a valid visa stamp for whatever status you were in at the time of filing your 485 and return on that type of visa. If you don't have the AP, your only option is to come in on a visa.
Dheeraj has this question that can I work for a US subsidiary and claim the experience to get into L1A or EB1C? No. It has to be in a foreign country. It cannot be in US. It cannot. That 1 year cannot be in US. It has to be outside only.
Wants to know if I'm on OPT EAD, can I do dual employment? I'm assuming you mean working for more than one company at the same time. Yes, that is possible on the initial 1 year of OPT. There's no limit on that as long as both jobs are directly related to your field of study.
Param Kumar from Facebook I worked for in multiple countries in higher level position, but when I came to United States in 2016 on H-1B, my employer filed an EB-2. Can I qualify for EB-1? Yes, you may be qualified for EB-1, assuming that you're working for the same company that you worked outside the country, and you're working for the same company here, you may be eligible. So the company has to, when I say same, I mean the ownership has to be a similar company, same. So if the owner, let's say for example, if you work for, let's say Schlumberger in France, and you're working for Schlumberger here, definitely you should consider yourself an EB1, EB1C category or L1. You can convert to L1A or you could directly file a EB1C. You should consider. But if you work in Schlumberger there, in France, and now you're working for Pepsi, there is no common ownership between both the things. Though. Then even though you may have supervised 2,000 employees in Schlumberger in France, but you're working with Pepsi and you're supervising 2,000 employees, you still are not eligible for EB1C. Okay? Only if Schlumberger in France and Schlumberger here, you would be qualified for EB1C.
CP wants to know, if I and my wife return to the U.S. on advance parole, will the H-1B and H-4 still be valid? So you can, after returning on advance parole, assuming you're working for the same company under the same terms and conditions of the H-1B, you can file an extension of your H-1B and H-4 status, and that approval of the extension puts you back in H-1B and H-4 status.
Satyasri is a very interesting question. His priority date is June 2013. He moved on to EB2, and is it advisable to downgrade though? One thing, he filed 485 in EB2. I would, if you don't have an I-140 under EB3, Satya, I would recommend get an I-140 in EB3. Be ready, but would I downgrade it right now and file it with the USCIS with the I-485J since the final action date is not current? No, I would not do it. I will prepare myself, make it ready, but I will not file the 485J until the final action date is current. Why? Because if you, let's say for example, you have an EB3 I-140 approval and you file the I-485J right now. What if the EB2 moves forward? Then what you're going to do? So that's the reason I would not do 485J, but I will get my I-140 approval in EB3 and make myself ready so that when the EB3 moves forward, I'll file the 485J.
All right, well, I think we're out of time for today. Thank you so much for joining us. We'll be back next Tuesday at 5 o'clock Central Time. And in the meantime, you can always go to our website to subscribe to our newsletter at rnlawgroup.com. There you can also find our consultation page and set up a consultation with any of our attorneys here at Reddy Neumann.
Thank you very much.